The January 6, 2021 complaint manually filed in the Wake County Superior Court Civil Division by Dr. Har on behalf of Crystal Mangum was a libel defamation action against media mega conglomerate Capital Broadcasting Company's WRAL-5 News and its then CEO James Goodman. Ms. Mangum found both online articles published in 2013 and 2014 to be inaccurate and defamatory in their headlines and text by referencing Mr. Day's demise as being a, quote, stabbing death, unquote, which it wasn't. And he did not die of any complications related to the stab wound and or its treatment, instead being electively removed from life support because of an irreversible comatose brain death resulting from an errant intubation in treating Mr. Day's delirium tremens. Because Mangum's overtures in 2 July 2020 letters by Har seeking to resolve the controversy surrounding these two articles were ignored by WRAL-5 News and its lawyer, litigation was the only recourse available to her. The relief she sought was an online correction in the headlines and text of the articles to reflect the truth that Mr. Day's death was not due to a stabbing. This, appended along with a brief comment about the manner of death as determined by Dr. Cyril Weck's 2019 report, which absolved Mangum of any criminality related to her boyfriend's death. North Carolina Statute 99-2A deals with circumstances holding publishers harmless if good faith false statements are corrected or retracted within 10 days of notification. WRAL-5 News was provided with notice of the falsity in its 2013 and 2014 articles in July 2020, with no correction forthcoming in 10 days or thereafter. Dr. Har was aware of the defamatory nature of both articles at the time of their publication, but he had no evidence for consideration by the courts to support the claims of the misleading media falsities that attributed death to a stabbing. That changed, however, with a submission of Dr. Weck's report of October 25, 2019. Which documented that the manner of Mr. Day's death was an accident and not a homicide. Attorney Amanda Martin filed a response and a motion to dismiss on behalf of her defendant clients, WRAL-5 News and its CEO, James Goodman. Plaintiff pro se Crystal Mangum, through her advocate Dr. Har, manually filed a motion for summary judgment requesting a judgment in her favor based on the facts and merits of the case, including Dr. Weck's report. Mangum also filed a motion to compel the Durham Superior Court's Criminal Division to unseal and produce a copy of the 18-page document from Dr. Clay Nichols' personnel folder, which the presiding judge deemed to be relevant to her November 2013 murder case, but which was withheld from her by an order allowing access to it for, quote, attorney eyes only, unquote. A calendar date during the October 25, 2021 session was set for a motions hearing in the case by either the defendants or the court. To assure her participation and consideration in the hearing, Har sent on October 4th a 2021 email to the Wake County Trial Court Administrator Kelly Myers, asking if Ms. Mangum was procedurally required to file a calendar date as well. 3 days later, on October 7, 2021, after not receiving a reply, Har electronically filed on behalf of Mangum a form seeking a calendar date for the session of October 25th. Under the motion type, Har filled in, quote, "Motion for summary judgment and motion to compel Durham Superior Court Criminal Division to unseal and produce 18-page document," unquote. Under special request was, quote, "Dr. Sidney Har be allowed to testify as a witness," unquote. On October 21st, 2021, days prior to the beginning of the calendar session of the 25th, Dr. Har Googled the judge assigned to preside over the hearing and learned that he was an attorney from Fayetteville who was recently appointed to the Superior Court by Governor Roy Cooper. This was considered problematic with regards to impartiality, as Har expressed in an email that day sent to the Wake County Trial Court Administrator, Ms. Myers. Dr. Har considered an attempt to reschedule for a session with a different judge, but the options were not especially good. Neither a Republican nor a Democrat with party allegiance to the governor would bode well in Mangum's quest for impartial adjudication. So conflicted advocate Har decided to roll the dice with the black rober already assigned, Honorable Judge Mark A. Sternlich. The one advantage being that there would be no additional delay. Weeks earlier, on October 6, 2021, Dr. Har sent Crystal Mangum a study guide in 2 spiral-bound manuals, consisting of a narrative of events and exhibits of evidence. The highly criticized mail delivery system utilized by the state's prison system obstructed conveyance of the packet to Mangum, and it was sent unopened, returned to sender back to Har, where he picked it up on Friday, October 22, 2021. With Crystal Mangum unable to access the study guide, her chief strategy was to call Dr. Har as a witness and to present to the court the exhibits of evidence, a plan discussed over the phone. With monitoring and recording of all inmate calls, the state was aware of Mangum's legal game plan. On Tuesday, October 26, 2021, Har sat in on the morning session of Judge Sternlich and was encouraged by what he heard from the recent Superior Court appointee of Governor Cooper. Specifically, Judge Sternlich argued that principles of equity are relevant because the court of equity, or fairness, in combination with the court of law, comprises the nation's justice system.
The other thing that you said is that you're talking about, I heard you say court of equity. We don't have courts of equity anymore, so that may be an abolished court with an abolished court.
Well, no, they're basically combined now. Yeah.
Sure.
The courts of law and courts of equity have merged into the general court of justice, and so I think, equitable principles certainly still
Judge Sternlicht that morning also stated that he tended to give latitude to pro se litigants to ensure justice. This in a case involving a missed statute of limitations.
I would say that our case, the motion that this is before you, is really based on procedural grounds, not substantive grounds, and they basically involve deadlines that were missed and failure to serve. So I'm not sure how you want to proceed, but I'm prepared to proceed if you
right. Well, and I think whether it's today or at a time when Mr. Abdul-Haq will be here, the outcome is likely to be the same. Under the circumstances, I'm inclined to allow the motion to continue that I haven't seen, but so that he has an opportunity to be present for this, as opposed to ruling on it in his absence under the circumstances. And I recognize that that's given him some latitude as a pro se party, but I think it's important that even pro se folks at least have the opportunity to be present and participate in the proceeding.
The Black Rober also showed grace by allowing a request for reconsideration of his earlier motion to dismiss a case when an attorney went to the wrong court and was absent during the one-sided argument of his opponent. After seeing Judge Sternlicht in action during his morning session, Dr. Haar had a glimmer of optimism that Crystal Mangum might get fair treatment at her hearing later that afternoon. Once the motions hearing commenced at 3:44 p.m., Judge Sternlicht made the following opening statement for the session. Quote, "All right, this is 21 CVS 308, Crystal Gail Mangum v. WRAL News and James F. Goodman. Present are Ms. Mangum and counsel for the defendants." Defense attorney Amanda Martin greeted, quote, "Good afternoon, Your Honor. Amanda Martin for both defendants," unquote. Judge Sternlicht then stated the motions on the agenda for the afternoon session. Quote, "This is plaintiff's motion for summary judgment, plaintiff's motion to compel, and defendant's motion to dismiss," unquote. Judge Sternlicht made it clear by this statement that Plaintiff Mangum's two motions were on the schedule in addition to the defendant's motion to dismiss. In other words, the defendant's motion to dismiss was not the only one on the court session's afternoon itinerary. Then, without allowing an argument or objection from Mangum, he laid down the following ground rules by stating, quote, "To me, it makes sense to hear the motion to dismiss first, because if that's granted, that would be the end of the case, and there wouldn't be a need to hear the other motions," unquote. This comment made it clear that the fix was in. The Black Rober clearly telegraphed his intent to first hear the defendant's presentation, make a desired ruling in its favor to dismiss, and then adjourn the proceedings without allowing Plaintiff Mangum to make a presentation. Depriving Ms. Mangum of the opportunity to present her case meant that she would not be able to call Dr. Haar to testify about the manner of death issues upon which the veracity of defendant's claim that Day was, quote, "fatally stabbed," unquote, rested. In addition, Haar, as a witness under oath, could express his own libel and defamation experience and lawsuit against defendants WRAL 5 News et al. As showing a pattern of behavior. Finally, as part of her presentation, Mangum was prepared to enter into evidence two manuals prepared by Dr. Haar that included a narrative of the case and exhibits of evidence. Denying Mangum the opportunity to present her case would prevent her from calling Dr. Har as a witness and from entering into evidence the two manuals in support of her case. Clearly, such a one-sided approach does not, by its very nature, seem to be fair. So it is likely that Judge Sternlicht tried to normalize it with his statement, quote, "So that's typically the way I have handled matters when there are multiple motions on a calendar for the same case," unquote. Judge Sternlicht wanted Ms. Mangum to believe that it was not only unusual, but routine in hearing motions from both parties to consider the defendant's motion to dismiss first, and if granted, dispense with the rest of the proceeding without allowing the plaintiff to present his or her case. The following exchange between the black rober and defense attorney supported that the defense was prepared to argue against plaintiff's motion for summary judgment. Quote, "Ms. Martin, thank you, Your Honor. I have a copy of the transcript of the deposition, but if you would prefer, I can hold onto that if we reach anything beyond the motion to dismiss." The court, "That's fine." Ms. Martin, "Obviously, it's only relevant with respect to the summary judgment." The court, "Right." Attorney Martin made two arguments to support her motion to dismiss. First, the one-year statute of limitations in which to file a libel defamation lawsuit had ran, and two, the media's fair report privilege, a privilege that protects accurate reports of government proceedings and public records. A pivotal point in the proceeding came when Dr. Har attempted to address the court. Quote, "Mr. Har, may I address the court?" unquote. To which the bailiff was quick to respond, quote, "No, you can't talk in here," unquote. Mangum, a pro se litigant, tried to bring Har as a witness to help assist her with her arguments. Quote, "Ms. Mangum, can I please, Your Honor, compel a witness to kind of help me," unquote. Judge Sternlicht was unyielding and denying the pro se's request. Quote, "No. This is a legal argument, and unless you've got an attorney who's assisting you, then you'll need to handle it on your own," unquote. Ms. Mangum implored the judge to reconsider by referencing Har's past experience with defendants to show a pattern of behavior. Quote, "Well, Mr. Har has personal knowledge of WRAL making defamatory statements towards him as well. He also," unquote. Judge Sternlicht's response made it clear that he would not be considering Mangum's motion during this hearing. Quote, "Well, Mr. Har is anything that he claims is defamatory is not something that is before the court in this proceeding. What we're talking about right now is the defendant's motion to dismiss your case based on the statute of limitations and the fair reporting privilege," unquote. In countering defendant's presentation, Ms. Mangum attempted to incorporate the credibility of the medical examiner, Dr. Clay Nichols, into the legal equation. Quote, "Prior to my November 2013 trial, the medical examiner was fired and under consideration for criminal investigation for his work in other forensic cases. And like I said on July 9th, 2020 and July 30th, 2020, Dr. Har notified counsel Amanda Martin of this report by Dr. Wack and gave them 10 days to respond," unquote. The 10-day reference is reflected in the NCGS Statute 99-2A, which reads, quote, "If it appears upon the trial that said article was published in good faith, that its falsity was due to an honest mistake of the facts, and that there were reasonable grounds for believing that the statements in said article were true, and that within 10 days after the service of said notice, a full and fair correction, apology, and retraction was published in the same editions or corresponding issues of the newspaper or periodical in which said article appeared, and in as conspicuous place and type as was said original article, then the plaintiff in such case, if a civil action, shall recover only actual damages, unquote. In large measure, Mangum's arguments consisted of references to Dr. Weck's report of October 25, 2019, which controverted the autopsy report upon which Mangum's conviction was grounded. And in her rebuttal, defense attorney Martin stated, quote, "The complaint is not with numbered paragraphs, but it says that, quote, the official record of Mr. Day's death was that he died secondary to complications of a stab wound to the chest," unquote. Mangum's position is that the official record is false, fraudulent, and unsubstantiated by facts. In referring to Mangum's complaint, defense attorney Martin continued, quote, "Second, in the complaint at page 12, the complaint describes Ms. Mangum's own lawyer as saying that Mr. Day had, quote, died of an infectious complication stemming from his wound, unquote. Truth be told, quote, Mangum's own lawyer, unquote, Daniel Meyer's admission of an infectious complication stemming from his wound, unquote, is unsustainable, being nothing more than a fabrication on his part. Neither in his written statements nor in his oral testimony does Dr. Nichols specify the supposed complication responsible for Mr. Day's death. So rather than strengthening defendant's argument that the official record regarding Day's cause of death was secondary to the stab wound he sustained, the averment about, quote, an infectious complication, unquote, lends credence to Dr. Hart's contention that Mangum's legal representation purposefully undermined and sabotaged her case. Before her concluding remarks, Attorney Martin touched on relief Ms. Mangum sought, stating, quote, "And in her description of what she would like to have happen, she has said she would like for WRAL to report on the Weck report," unquote. Clearly, the report by Dr. Weck is exonerative and favorable to Ms. Mangum. The defense attorney continued, quote, "But, of course, the First Amendment gives the defendants the right to decide what they report, what is newsworthy," unquote. Dr. Weck's report is newsworthy, as it challenges the correctness of Mangum's second-degree murder conviction. It places responsibility for Mr. Day's death on medical staff at Duke University Hospital, and it destroys the credibility of the medical examiner, Dr. Nichols, upon whose report the vendetta and racist manifest injustice was cultivated. Unfortunately, the media is biased and has an agenda, and there are some stories about which the media does not want the people to know. Before ruling on the defendant's motion to dismiss, Ms. Mangum made one final effort to get the documents in support of her case admitted, as detailed in the following exchange. Quote, "This is well, first of all, I have some papers for you to look at," unquote. The court, "What do you have?" Ms. Mangum, "Oh, it's actually your copy of my argument," unquote. Ms. Mangum was referring to the two manuals that Dr. Hart had prepared. The black rober continued, quote, "The court, your argument?" Ms. Mangum, "Uh-huh." The court, "Which argument?" Ms. Mangum, "That I should have a motion for summary judgment," unquote. Judge Sternlicht made it clear that he would not be taking Mangum's motion into consideration. Quote, the court, "Okay, we're not to the summary judgment at this point. We're talking about the motion to dismiss." Ms. Mangum, "Oh, okay, all right." The court, "Do you have anything further about the motion to dismiss based on the statute of limitations and fair reporting privilege?" Mangum's Hail Mary was a reference about Dottie Ampty, a white Cary housewife who, in an argument over television viewing, strangled her debilitated ethnic minority husband, Sherrod, with her bare hands. Medical examiner Dr. Clay Nichols determined that Sherrod Ampty died of a heart attack he suffered while in the process of being strangled, and that the manner of death was therefore natural causes. He also advised that Dottie Ampty should not be charged with murder or manslaughter, but rather only assault. The autopsy case, which was supervised by Dr. Nichols, who was serving then as North Carolina Deputy Chief Medical Examiner, was reviewed by the Office of the Chief Medical Examiner, which overturned the ruling espoused by Dr. Nichols and instead declared that the manner of death was a homicide. Dottie Ampty accepted a plea deal for voluntary manslaughter, but because of the two contradictory autopsy reports, the judge sentenced her to time served, which was 1 year in jail awaiting trial. Judge Sternlicht was dismissive of this argument by Ms. Mangum and stated his intentions. Quote, "I'm going to grant the motion to dismiss, finding that as a matter of law, the complaint shows that it should be dismissed because it was filed beyond the statute of limitations and because the publications complained of are protected by the fair report privilege. I'll prepare an order setting that out." Unquote. After Judge Sternlicht made his ruling, Miss Mangum tried one last time to submit her two manuals into evidence. Quote, "Okay, am I allowed to give you this?" Unquote, she said, holding up the two spiral-bound documents. Judge Sternlicht replied, quote, "No, ma'am, the case is dismissed, and so the summary judgment motion is not going to be heard, and that's not something that will go into the file." Unquote. At 4:19 p.m., the hearing was adjourned without Miss Mangum being permitted to present her case, without Dr. Har being allowed to testify as an advocate on the issues involving Miss Mangum or about his own libel and defamation legal issues with WRAL 5 News and its CEO James Goodman. On November 1st, 2021, Judge Sternlicht filed his two-page order in which he acknowledged that the session was about defendant's motion to dismiss and plaintiff's motion for summary judgment and to compel Durham Court to unseal and produce 18-page document. The judge is misleading at best when he claims to have, quote, "considered arguments of plaintiff and defense counsel," unquote. The only motion under consideration was the defendant's motion to dismiss, and he specifically prohibited Plaintiff Mangum from presenting her case, calling her witness, or submitting her documents. This session under Judge Sternlicht was, in essence, an ex parte hearing for the benefit of one side only, that of the defendants. And as such, it was unlike the two citations the Black Rober referenced of Desmond v. News and Observer Publishing Company and Lacombe v. Jacksonville Daily News Company. In these two cases, the plaintiffs were allowed to present their case, unlike Miss Mangum. Also, Mangum's case sought a correction of a defamatory published statement to reflect the truth, as opposed to a straightforward libel grievance. Judge Sternlicht dismissed Crystal Mangum's case with prejudice. meaning that she could not refile it in Superior Court again, barring appellate intervention.